Hi, everyone. This is Meredith Kayafa with Morris, Manning & Martin. Thank you all for joining us today. And at the top, we all wanted to say that in these very difficult times, we hope that everyone out there is safe and healthy and that all your families and friends are staying safe and healthy too. We're here today to discuss the law, and of course, to all of us and to all of you, the law is really important, but the most important thing right now to remember is that this, at the end of the day, is a very human issue and a public health issue, and we want to do all that we can to help you, help yourselves and your families and your customers and your employees and everyone that you care about make the best decision that you can in these difficult times. We'll go through the law as we know it today and how it might apply to the difficult issues that you're facing, but as all of us know, there are always lots of questions in these situations that the law simply doesn't answer, and we here at Morris, Manning & Martin are committed to helping you make the best decisions that you can amidst great uncertainty and great stress. So thank you all for joining us today. Just to quickly run through the things that we'd like to cover, obviously the Families First Coronavirus Response Act, which was just passed this past week, is at top of mind, so we're going to talk about that. Unfortunately, many of us and our clients are dealing with having to make hard decisions about reducing headcount at their companies. So we'll talk about major legal issues if you are in the position of having to make those tough choices. Wage and hour issues right now are being implicated in lots and lots of different areas and changing constantly. We're also dealing with an unusual situation of everyone working remotely, and there are employment law implications for that too. So we'd like to talk about all that. And my partner, Scott Wagner, an expert in employee benefits, will be discussing employee benefits issues and tax issues that have arisen with all of these new rules. To start, the big news this week, President Trump signed into law the Families First Coronavirus Response Act. This law is truly, I think, revolutionary in the employment world. It's created major changes that companies have not previously had to deal with, namely required paid sick leave for employees mandated by federal law, which we didn't have before. It's also providing tax credits for employers, expanded access to unemployment insurance, and healthcare coverage mandates for COVID-19 testing. The first major component of the law is the Emergency Family Medical Leave Expansion Act. This is part of the law that drastically expands the FMLA. The second part of the law is an Emergency Paid Sick Leave Act. Those two laws will go into effect within the next approximately 13 days. There's a little bit of uncertainty whether that means definitely as of April 2nd, it will be in effect, or if it could possibly happen earlier. We'll hopefully know more about that in the coming days, but I think it's reasonable to suspect probably as of April 2nd, and these new rules will last until December 31st, 2020. So the first part of the law, the expansion of the FMLA, the big change is that employers are now required to provide up to 12 weeks of emergency paid leave for eligible employees who are unable to work or work from home. Telework is the word that the statute uses for that, due to the need to take leave to care for a son or daughter whose school or place of care has closed due to COVID-19. This new rule applies to a much broader category of companies and employees than the previous FMLA. Employees who are eligible to take this new paid leave are all employees who have been employed for at least 30 days. This is for the FMLA component of the law. You'll see when Abby talks to you later, that 30-day requirement does not apply to the paid sick leave component. But in terms of this type of FMLA leave, if there's a school closure and you need to take care of children, applies to employees who've been there for at least 30 days. And in terms of the employers who must provide this coverage, this is also a big change. Now, private employers with less than 500 employees must provide this leave. It also includes all public sector employers and all governmental entities. And it's noteworthy, and the clients that we've been discussing this with have found it very strange that it's the largest companies who at this point are exempt from this law. That is in fact the case. The very largest companies that have 500 or more employees this does not apply to them. And keep in mind, as you're dealing with this issue of how many employees do I have, there are rules regarding how you have to count your employees. There's a test under the FMLA, which we believe the same test would apply under the new FMLA, the expanded FMLA, that's called the Integrated Employer Test, which means, you know, speaking very generally, that if you have multiple related entities, parents, subsidiaries, brothers, sisters, and there is a high degree of interrelationship in the operations or the management or the structure of these companies, there's a chance that you would count them together for FMLA purposes. So if that's something that is very detailed and fact specific, let us know if you have any questions about how you count your employees in your, you know, corporate group. So the big question on everyone's mind with this, of course, is how much is it going to cost? During the period of leave, employers are required to pay eligible employees at least 2/3 of the employee's regular rate of pay for the number of hours that the employee would otherwise normally be scheduled to work. This is capped in the latest version, the version that was passed, at $200 a day and $10,000 in the aggregate for any individual. The first 10 days of that must be or may be unpaid, and you'll see there's an intersection when Abby talks to you, because under the Paid Leave Act, those 10 days would likely be covered. So you would be paying for them through the Paid Leave Act, but under the FMLA rules, technically you could make those first 10 days unpaid. Another important issue with this is that in the final version of the bill, employees may choose to substitute other PTO, accrued vacation, or similar structures for any part of the leave period, including those first 10 days. That's something that has been controversial. There was much debate about this. A previous version of the law specifically prohibited employers from requiring employees to use PTO or accrued leave. That prohibition was taken out of the final version, but we're left with this language that says employee may substitute it. So it somewhat leaves the question open of, can an employer require them to do that? That's something we will hopefully get further guidance on, but right now as it states, an employee can choose to do it. There's no direct prohibition on an employer requiring it, but employers that want to require that should just know that this is an area of uncertainty in the law. There's also, as with the previous FMLA, the traditional FMLA, the requirement, the job protection requirement. You have to restore everybody back to their original position when they come back from this leave. There is a rather complex exception for very small employers with less than 25 employees. Several conditions have to be met, largely dealing with being able to demonstrate that you tried very, very hard, but were nevertheless, because of factors out of your control, unable to restore them to their position. But that's the only real exception that we have to that requirement. And now I will turn it over to my colleague, Abby Larimer, to talk to you about the second component of the new law, the Paid Sick Leave Act.
Hi, everyone. So second major component of this law that affected employees and their ability to take leave is the Emergency Paid Sick Leave Act. So here, employers are required to provide all employees with 2 weeks of paid sick leave if the employee is unable to work or telework because the employee is subject to a government-issued quarantine or isolation order. We're seeing more of those pop up, or if they've been advised by a healthcare provider to self-quarantine due to concerns related to coronavirus. If the employee is caring for an individual who is subject to such an order or has also been advised by a healthcare provider. If the employee is experiencing symptoms of COVID-19 and is in the process of seeking a medical diagnosis, if the employee is caring for a child whose school or place of care has been closed to due to COVID-19 precautions, and also if the employee is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services. So who does this act apply to? All employees are eligible, and covered employees, again, we have this private employers with less than 500 employees, all public sector employers, and also all governmental entities. So how much is this going to cost? So as we said, full-time employees are entitled to approximately 2 weeks or 80 hours of paid sick time. Part-time employees are entitled to paid sick time for the number of hours that the employee works on average over a 2-week period. The amount of emergency sick wages that an employer may pend is going to depend on the reason for the employee taking leave under the Act. So first, employers will be required to pay emergency sick time at the employee's regular rate of pay, and that regular rate is looking at how it's defined in the Fair Labor Standards Act. So it's the regular rate of pay capped at $5.11 per day and $5,110 in the aggregate if the employee is taking leave because the employee is subject to a quarantine or isolation order, advised by a healthcare provider due to self-quarantine, or is experiencing symptoms and seeking a medical diagnosis. Employers will be required to pay emergency sick time at 2/3 of an employee's regular rate of pay, capped at $200 per day and $2,000 in the aggregate, if the employee is taking leave to care for another individual subject to an isolation or quarantine order, or someone who has been advised by a healthcare provider to quarantine, to care for an employee's child if the school or place of care has closed, or again, if their employee is experiencing another substantially similar condition that's going to be specified by the Secretary of Health and Human Services. Emergency paid sick time is going to be available for immediate use regardless of how long the employee has been employed, and that's a change from the component of that expanded the FMLA. It stops beginning with the employee's next scheduled work shift following the termination of the need for leave. So once the employee no longer needs leave, that's going to stop by their next scheduled shift. There's no carryover to the following year, and similarly, if someone's terminated, there's going to be no requirement to pay out or reimburse the employee for unused paid sick time under this Act, and that's something that also can be very different compared to other state paid sick leave laws. Other requirements for employers. Employers are not allowed to make an employee search for or find a replacement to cover their hours when they're taking leave under the Act. And it's also unlawful for employers to discharge, discipline, or in any other way discriminate against employees who take leave accordance in the Act, or file a complaint or institute or cause any proceedings related under this Act, or who testify in such proceedings. So that's similar language to other anti-retaliation provisions you see in other employment laws. Employers can require employees to follow reasonable notice procedures after they take their first day of leave. Some additional requirements are that employers are required to post and keep posted a notice describing the requirements of the Emergency Paid Sick Leave Act. We are hoping within 7 days that the Secretary of Labor is going to make a model notice publicly available that meets all of these requirements. However, that's not available yet, but hopefully that'll be good guidance for employers to know what exactly it is that you need to be telling your employees about the new law.
And something also with that on the FMLA portion, the new law doesn't contain a new poster requirement for the FMLA portion. So it appears that means that the previous FMLA poster rule might apply to employers who didn't have to have a poster before, but now they're covered by this emergency FMLA Act. So if you have questions about that, if you're an employer that previously didn't have to do anything and now you do, we think best practice would probably be to plan on posting some kind of FMLA notice to your employees.
And one other interesting question too is that when you have everyone working remotely, typically we see these posters that are hung in sort of a coffee room or break room, and most likely you're not going to have any employees there now. I don't know whether this requires affirmative emails to be going out to every employee on it, but I think if you have a portal, certainly you're going to need to post this in your online portal, and I think it's better to be safe and sorry to make sure your employees know about that. But that's something to think about too. I mean, this isn't just going to get tacked up in a room, probably where no one's going to be looking at it for a little bit. So any exceptions, yes. An employer may elect to exclude healthcare providers and emergency responders. For the definition of healthcare providers, we're looking to how that's defined in the Family and Medical Leave Act. FMLA defines healthcare providers as basically a licensed doctor or any other person determined by the Secretary of Labor to be capable of providing healthcare services. Emergency responders, there's so far no reference or definition that's been provided. Additionally, the Secretary of Labor has the authority to issue regulations for good cause that can exclude healthcare providers and emergency responders from the definition of eligible employees, so that it may not be just up to the employer to exclude. Also to exempt small businesses with fewer than 50 employees if the imposition of the Paid Leave Act requirements are going to jeopardize the viability of the business as a whole going forward, and then just as otherwise necessary to carry out the purposes of this act. So I know a big question on your mind is probably, how are we as employers going to afford this? So payroll tax credit, the messaging from the government is that, employers are going to be made up whole from this. Payroll tax credits that are going to be equal to 100% of the qualified leave wages, subject to the same caps. Further, the Secretary of the Treasury is authorized by the Act to issue additional regulations and guidance, and this is including possible cash advances to many employers that are going to need those just to be able to comply with the requirements of this Act. So Secretary of Treasury has been making statements recently saying that the U.S. Treasury is going to use its regulatory authority to advance these funds to employers to protect businesses that are having specific concerns about cash flow, and employers will be able to use cash deposited with the IRS to pay sick leave wages. I'm going to turn this over to Scott Wagner now, who's going to talk some more about tax credits under this law.
Thanks, Abby. And I thought we would take a few minutes to dive down into the mechanics of the tax credit a bit so that everybody can understand exactly what's going on with regard to tax credits and how it works. It's a common question we're getting now, if we are going to have to provide this extended leave or sick pay, how does the credit process work? And a concern that we've received from some employers is that they would have to wait until they file their annual income tax filing to be able to get a refund or credit. And so I wanted to take a few minutes to go through that. So the way that this will work is through a refundable payroll tax credit for the employer portion, but not the employee portion of Social Security tax. That's the 6.2% of employees' wages up to the first $130,000 or so until Social Security gets allocated. And the way it'll work is there will be a tax credit that will be allowed to offset for wages paid to employees due to the paid sick time leave. So it can be claimed on a quarterly basis. You wouldn't have to wait until the corporation files its income tax report for the year. It's refundable, so it's a credit against taxes that the employer has to pay towards their Social Security employer side and Social Security taxes. If there is an excess, the employer can take a refund in the quarter in which they apply it. Employers don't have to apply the credit. They can roll it forward to another quarter. Employers must include the amount of the credits that they received in their gross income, though, to prevent double counting. And then wages considered and determined payroll credit cannot be used to determine the amount of credit under other IRS tax code credit rules. So the sick leave credit for each employee will be the 100% of the wages paid, including qualified health plan expenses. And a qualified health plan expense would be an employer contribution toward the cost of health insurance related to the wages that are paid. So if you have to pay someone who's out on sick leave, and as a result, that employee is still eligible for health insurance, and we're going to get into the rules about when somebody is and is not going to be subject to eligibility rules under the health plan and still to be determined to be an active employee. But if you are paying someone under sick leave laws and they are still eligible for the health plan, you're making contributions to the health plan on their behalf, that can be counted as wages that you can receive a refundable tax credit for. It's up to $511 per day while the employee is receiving paid sick leave to care for himself or herself, and $200 of caring for a family member or child whose school has closed. The sick leave credit is limited to 10 days per employee per quarter, and the family leave credit for each employee will be for wages, including qualified health plan expenses, up to $200 per employee per day, and $10,000 in aggregate for all calendar quarters. That's the family leave portion. So different thresholds whether you're paying sick leave credit or family leave credit. Wages under the Act that you pay to employees will not be considered to be wages or compensation for purposes of Social Security. So there's a benefit to the employee as well. They are still considered to be subject to income tax. And with that, I'm going to turn it back over to Abby and Meredith, who are going to talk about some of the other recent legislation that we've had.
Thanks, Scott. So another component of the new federal law is called the Emergency Unemployment Insurance Stabilization and Access Act. The long and short of this is basically the federal government is giving a whole lot more money to the states to help them expand their unemployment programs and provide unemployment benefits to more people. They're giving the states $1 billion in additional money, and in exchange for receiving that money, states are going to have to loosen some of their eligibility requirements for unemployment, such as work search requirements or waiting periods. And the way that the funds are going to be divided up is that half of them are going to be used to provide immediate additional funding for staffing, technology, and administrative costs. And the other half will be emergency grants to states that experience more than a 10% increase in unemployment. And there's some conditions for the states to receive these grants. They have to meet certain additional requirements, including employers are going to have to notify employees of the availability of unemployment compensation at the time that employees are separated from employment. So the Secretary of Labor is going to be issuing some model notification language that states will now require all employers in their states to use whenever they let someone go. And there are some states, such as Georgia, that already have this requirement. You already in Georgia are required to provide, a separation notice whenever you let people go. Not all states have that requirement. So we are just going to have to wait and see what we get from the Secretary of Labor on specifically what employers will have to say. So turning away from the new federal legislation, the next thing that we wanted to discuss today is the difficult situation that many companies are facing now of having to reduce their headcount related to COVID-19. And generally, we wanted to touch on sort of 3 basic types of reductions that you might be considering or employing. These words tend to be used kind of loosely and vaguely, and so I just wanted to kind of explain what I mean when I'm using these different terms. The first is a furlough or a reduction in hours. The second is a type of permanent or temporary layoff. And the third major category is facility closures. Furlough, when you hear the word furlough, generally what that means is you're not actually terminating people's employment. You are instead reducing the days or weeks that they work, and they are not performing any work at all. So your employees are still technically employed, but they are under strict instructions that they are not allowed to perform any work. And as a result, you will not be paying them while they're on a furlough. Typically with furloughs, employees are still entitled to receive benefits, even if they're not receiving a paycheck. And they also may be able to use accrued but unused PTO if they're on a furlough. But the key is they're under strict instruction not to work, and they're not being paid for working. And if you are implementing or need to implement a furlough, there are policies that you can put in place, communications that you can provide that clearly set out what the parameters are, because as you'll see when we discuss wage and hour issues later, the important thing with furloughs is that people aren't working, because if they are working, then under the FLSA, you have to pay them. One of the questions that we receive often with furloughs is, are my employees entitled to collect unemployment compensation while on furlough? Generally, the answer to anything related to unemployment is going to be, it depends on the state law, wherever you are. So those of you that have multi-state employers and that have employees in many states, this is something, that I know you're used to dealing with employment law in general, but you'll have sort of a patchwork of different rules depending on the state law where people are. But, generally many states do provide some measure of unemployment for people while they're on furlough. Sometimes there's a way under state unemployment law where you can actually structure a furlough to maximize the unemployment benefits that people can receive. So that's something that if you're looking to increase your cash flow, reduce your headcount temporarily, but with as minimal disruption as possible to your employees, a furlough structured to combine in a beneficial way with unemployment can be a good option to consider. The second major category of types of reductions is a layoff. And a layoff is different from a furlough because in a layoff, there's an actual termination of the employment relationship. People are actually terminated and they do not work for you anymore. You can have a temporary layoff, a layoff that is communicated out as being temporary, or you can have a permanent layoff where it's going to be something that is permanent, not expected to be temporary. This is a big issue when you're talking about whether the WARN Act applies, and that's why the slide references this 6-month guide point, because 6 months is an important distinction for whether or not you will have to provide notices under the federal or state WARN Acts. Under the federal WARN Act, 60 days notice is required. Generally, if you're doing a layoff that is longer than 6 months, but if it's less than 6 months, your WARN Act obligations might not apply. So a temporary layoff, generally you want it to be less than 6 months. You also have to be able to establish that you had a good faith belief at the time that you made the layoff that it would in fact be less than 6 months. And that's something that is, again, very fact specific. How strong is your position that really this layoff will be less than 6 months? But that's important to consider with WARN Act issues. And when you're talking about layoffs and the WARN Act, another question that often comes up is, surely there has to be some kind of exception for this. This is a global pandemic that none of us, even as far as, a week or two ago, I think imagined that it would be quite this bad. Is there an exception to that? And the answer, which I know is your favorite answer to get from your lawyers all the time, is, well, possibly. The federal WARN Act has provisions, and most state WARN statutes, not all, but most, have provisions addressing terminations related to natural disasters or calamities. Unfortunately, this is new territory, and those provisions have not been interpreted clearly as applying in the case of an epidemic like COVID-19. I personally think that there are excellent arguments that this pandemic should be considered similar to the types of issues that Congress was thinking about when they passed the WARN Act and they wrote that exception, but that is an area of legal uncertainty. Some states are starting to take action on this issue. The governor of California recently suspended the advance notice requirement under the California WARN Act, which those of you with California employees know that California is a quagmire of employment law, and the WARN Act is no exception. WARN Act requirements in California are much more stringent. But the governor has said that he will suspend the advance notice requirement, and other exceptions may apply based on layoffs due to COVID-19. But it is important, to note with these exceptions, if you're relying on one of them, generally you're still required to provide as much advance notice as you can. The exception won't completely relieve you of the obligation to provide a notice. It'll just say, okay, this is a pandemic nobody knew about, but at the point that you knew about it and you knew that you needed to make a layoff, you need to provide your notices if you're covered by federal or state WARN Acts. Other important considerations for temporary and permanent layoffs. These are actual terminations of employment, so the normal things that you have to think about with terminations will apply. Compliance with state-specific laws regarding wage payouts and payouts of accrued but unused vacation. In addition, something to consider if you're doing permanent layoffs, if it's financially feasible, is you could consider providing severance benefits in exchange for a release agreement. And again, the same legal considerations would apply to those severance agreements. You have to make sure that if you are providing severance in exchange for a release to terminated workers over the age of 40, that they comply with all the ADEA and OWBPA requirements. And if this is a large layoff, or, it doesn't even have to be a large layoff. If you're laying off a group of employees over the age of 40 all at once, then you have to comply with the additional requirements under the ADEA and provide additional time for them to think about signing the release and provide disclosures regarding certain information about the group of employees considered and chosen for the layoff. The third type of reduction that you might be facing in addition to furloughs and layoffs is facility closures. These are going to be implicated probably more and more now as we're seeing that state governments are considering requiring companies to stop their operations. So if there's an order, if the government requires anybody to temporarily or permanently close, this could constitute a facility closure. So this is something where it's really important to monitor state-specific updates about business operations with your particular business. Again, facility closures, the same set of considerations. Whenever you're closing a facility or laying a group of people off, you need to think about the WARN Act and whether it's going to apply and whether it requires you to provide advance notice. Closing a facility or discontinuing an operating unit, so not even an entire facility, that impacts at least 50 employees at a single site of employment can trigger notice requirements under WARN. And there are some state mini-WARN Acts that don't even have threshold numbers of employees requirements. If you're closing down a whole facility, even if it's not very many people, you might have a WARN Act situation. And in addition with that, again, it doesn't even have to be closing down a whole physical building. If you're letting go an entire department, even if it's not something that seems like it would trigger WARN, even if it's not a large number of people, if you are discontinuing a whole operating unit or letting go a whole department, it could be a facility closure that triggers WARN. And with that, I will turn it back over to Scott to discuss some employee benefits considerations with layoffs and reductions of hours.
Thanks, Meredith. So I wanted to take a few minutes just to talk about some of the routine benefits questions that we get in connection with layoffs, reduction of hours, and furloughs. This is going to be case by case in most respects, and a lot of this will depend in part on the terms of your plan document. But I wanted to go through a few of these scenarios in general to talk about what you could expect, especially since we're all using new terminology of layoffs and reductions and furloughs. So layoffs, it should be treated just like a normal termination, right? A layoff is an actual termination of employment. It should be treated like that for benefit plan purposes in most respects. That means that the terms of the plan will govern when coverage will end. So you'll need to determine, does coverage extend through the end of the month for a health plan? And you'll need to communicate those to employees typically at the time of layoff. I like to put it in the layoff letter if you're doing a letter. You'll also want to provide information about COBRA if they're entitled to COBRA. So this would be a qualifying event under COBRA if they lose health plan coverage as a result of a termination of employment. So layoff's really no different than any other termination you're used to, just with more folks. A reduction of hours will be more tricky, and you'll have to look at the terms of the plan document to determine whether, on a case-by-case basis, these employees can still stay covered under the health plan or your other benefit plans. A lot of times, benefit plans will exclude from eligibility part-time employees or employees that work below a certain threshold. The real thing to watch out for here are your Affordable Care Act measurement periods. If an employee's hours are reduced, but the employee is still in their ACA stability period, then you will still need to treat them as a full-time employee through the end of that stability period. So the Affordable Care Act added these measurement periods and stability periods where you measure employees' hours to determine who's on a full-time or part-time basis for purposes of providing them an insurance. If you are have more than 50 full-time or full-time equivalent employees and you're considered a large employer under the Affordable Care Act, then you still have to comply with the ACA rules to provide each of your full-time employees an offer of coverage under your group health plan to avoid potentially paying for a penalty. Those rules work to track employees' hours who might be full-time, might be part-time, where you can't quite tell if they're going to be in full-time status for a period of time. And you would generally need to still apply those rules. So even if you've got an employee who was full-time or had been part-time but trending full-time and you gave them an offer of coverage, if they're in their stability period, then you'd still need to continue their coverage through the end of that period. And the way to do that is to talk to your broker or your service provider, whoever's helping you run your ACA measurement period, to determine whether that applicable employee would still need to be offered coverage to the remainder of the stability period. The question that we get commonly is whether a reduction in hours is a Section 125 election change. So Section 125 allows employees to participate in group health plans on a pre-tax basis. And those rules have very specific requirements to be able to change an election mid-year. Generally, a reduction in hours is not by itself a reason to be able to allow people to change their elections. The only time you'd really be able to change your election is if you have another family event going on, like you have a birth of a child or someone loses employment in the family, or you lose insurance as a result of the reduction in hours. So if you're the type of person who you're in a reduced hours, but you're still eligible for the health plan, even though you're making less money, that may not be enough to trigger an election change event. Furloughs are effectively a reduction in hours. So this is kind of a newer term that some of our clients aren't quite familiar with. Just wanted to make sure everybody's aware it is a reduction in hours for benefit plan purposes. So again, you'll have to look at the plan document to see what happens when you put an employee on furlough. Some plan documents will specifically say if it's an employer involuntary furlough, benefits will continue for a period of time. So unlike a reduction in hours where you're just measuring someone's hours to determine whether they're full-time or part-time, you need to check your plan documents to see whether the plan enables people to stay on during a furlough. A lot of times, if your plan document is silent on this or doesn't provide for furlough coverage, you'll need to add it to your health plan. And to do that, you'll need to talk to your broker or your carrier if you're a fully insured plan, or your stop-loss carrier if you're a self-insured plan. A lot of our clients are calling about making the change without checking with the right parties. And if you do that and you extend coverage where your plan does not provide for coverage without getting approval from your carrier, or for self-insured plans, your stop-loss carrier, then they can deny those claims. And in that case where the employer has represented that the employee is covered, there's a good argument that the employer could be on the hook for any charges that are incurred by the participant during that time. One of the key issues here is to determine how employees will pay for the coverage while they're out. So if you are extending coverage while someone is on furlough, how are they going to pay for coverage? If they're not being paid, there is either one of two things has to happen. Either the employee has to cut a check and pay the employer on a biweekly or monthly basis so that they continue to make their health plan premium payments, or some employers are choosing to pay the employee portion of the health care coverage for them on their behalf, and then they recoup it when the employees come back. You can generally do this, but to do it, it needs to be documented. So you'll need to have either a letter to the employee explaining what's going to happen, and ideally, you'd like to have something where the employee signs off on it, because when the employee returns, you're going to recoup it from their paycheck a lot of times. If you're recouping from the paycheck, there are state state payroll rules that will generally prevent you from deducting from people's paycheck without authorization. So you'll want to make sure you're checking with your local payroll rules and also getting any type of acknowledgement or signature from the employee before you recoup. A lot of times if the employee does not return to work, either at their own accord or because they're not called back after the furlough, or the furlough becomes a layoff, then the company has a couple of options that it kind of depends on how you've documented it. Sometimes, and in some states, you can recoup from a final paycheck. That doesn't work in every state, so you'll have to consult with counsel before you do that. For COBRA, COBRA requires a termination of coverage. So if you put people on furlough, but there's not a termination of the health insurance, then you only have one of the two parts needed for a COBRA qualifying event. You only have a reduction in hours. You don't have the loss of coverage that goes along with that. And if you don't have the loss of coverage, then you can't offer COBRA. I wanted to talk about a few retirement plan issues. A lot of this is still to be determined. Last night, the Senate passed a bill providing retirement plan relief. It would provide a waiver of the 10% early withdrawal penalty for distributions up to $100,000 for coronavirus-related purposes. It would have to be yourself or a family member would have to be diagnosed with coronavirus, and it's not clear what type of evidence you'd have to submit to the employer to demonstrate that. I expect that we're going to get further guidance on that in short order. Income attributable to the withdrawal would also be subject to a 3-year tax. You could pay the tax over 3 years. And there would be a mechanism for you to be able to pay that distribution back to the plan without it being taxable within that 3-year period. The bill would also provide flexibility to loans for certain retirement plans for coronavirus-related relief. And none of this is effective yet, and I expect there to be some changes. So sort of stay tuned on that. We'll be putting out an alert on that as soon as it's final. Some retirement plan reminders in the meantime, pending the new rules. Keep in mind what's eligible for deferrals and what your plan says is eligible to, compensation for both deferrals, but matching, are you paying people while they're on furlough? Generally, furlough pay is wages, and as wages would likely be compensation for purposes of your 401k plan. Of course, you would need to check your 401k plan and talk to your service provider to confirm that your plan is set up and doesn't specifically preclude something like a furlough pay. But generally, furlough pay would be includable income and could be deferred. That's different from separation pay, right? Separation pay generally is not compensation, subject to deferrals or matching into the 401k plan. And so you would need to just stay on top of, what are we really paying this employee for? Is this really separation pay that we're paying them over the next couple of weeks? Or is this furlough pay? And you could talk to counsel or consult with your advisors to determine the proper treatment. Wanted to make everybody aware of the plan loan repayment cure period rule. So your plan will have, if it allows for plan loans from the 401k plan, will have a cure period most times. And there's a maximum cure period that your plan could have, where if people miss a loan payment, so like if you put someone on furlough and they have a plan loan and they're repaying their plan loan over time, if they miss a payment, there's generally a cure period, and you'd have to check your plan document to determine what the cure period applicable to your plan is. The maximum is the end of the calendar quarter, the second calendar quarter following the missed payment. So in the case where somebody misses a payment, they could come current by making up the plan loan before it defaults. If it defaults, they don't make it up by the end of the cure period, then it would be considered taxable income to them and potentially subject to a 10% penalty. It's not entirely clear how that would work in the case where we're allowing a waiver of a 10% penalty for distributions related to coronavirus, but I expect further guidance on that shortly. Pay attention to distribution requests. Participants might say, I need to take money out of my 401k plan. Make sure that they actually have a real distribution event. If they're on furlough, a lot of times their their employment has not officially separated from the company, and that would not generally, without anything else, be a permitted distribution event. Also watch for partial plan termination. So if you separate more than 20% of your workforce in a year, it's presumptively a partial plan termination. There are a lot of facts and circumstances that would need to be taken into consideration and to look at whether these are voluntary or involuntary terminations. But just to put that on your radar, if there is a partial plan termination, you would need to vest all affected participants and their 401k balances effective as of their termination date. Last thing to note, hardship requests. I expect there to be an increase in hardship requests. We don't know exactly whether the new rules will allow for relaxed hardship in case of coronavirus. New rules that went into place earlier this year allow for self-certification of hardship requests. So participants should be able to self-certify, and I think a lot of you or your service providers have put those rules in place already, and so they should be already doing that. And so that should help with some of the documentation that folks need to submit to be able to get a hardship distribution from the retirement plan. And with that, I'm going to turn it back over to Abby and Meredith to talk about some wage and hour issues.
Thanks, Scott. Well, wage and hour is a really tough issue for a lot of employers under normal circumstances, and I think this is just really going to complicate it even more. One thing to keep in mind, too, when we're talking about wage and hours laws, we have federal laws and we have state laws, and these are all very employee-friendly laws with a lot more teeth in them than your, general employment laws have. And in the case of a gray area, it's usually going to go down on the side of the employee. So just something to keep in the back of mind. Certainly ensuring compliance with timekeeping policies is going to be critical when we're managing a remote workforce. I think, when we're talking about exempt employees, those who are exempt from minimum wage and overtime requirements, and then non-exempt employees, regardless of classification, we really think it's important for employers to be taking steps necessary to ensure that everyone is accurately reporting time in accordance with company policy. Particularly important for non-exempt employees. Non-exempt employees should not be performing any work off the clock, and also should not be performing overtime without prior approval. If you have that policy in place, I think it's good to remind employees about what your timekeeping policy is now, particularly about overtime work, because that's going to be more difficult to manage with a remote workforce. Keep in mind, you do still have to pay overtime work, even if it's not been previously authorized. Additionally, if you have a timekeeping or a falsifying time policy, always keep in mind it could be a good idea to remind employees about that. For exempt employees, keep in mind you still can use timekeeping as a means to ensure that employees are performing work when they're out of the office. And then, do be cautious about making certain salary modifications if an employee is not performing work as they're required to do. Additionally, employers, if you are in the instance where you're having to make compensation changes, be wary of state and situation-specific requirements that prevent a unilateral change in wages or other compensation. There's certain states that have specific requirements that you have to provide certain notice to employees before you're modifying their pay. You also want to check whether you have an employment contract, if there's a collective bargaining agreement, or any other policy or practice that could prevent you from making a unilateral reduction in an employee's wages. So furloughing, that may also involve changes to pay practices. And you want to make sure, if you are doing furloughs, that you're doing it in a way that is not going to interfere with an employee's exempt salary status. The easiest way to do this, safest way, is just if an employee is furloughed, to have them not performing any work for that week. If an employee is on a furlough and not getting paid for work they're performing that week, and they do something like check an email or answer a question, that could put the whole thing at risk. And again, that's a pretty small, barrier. If someone's just checking a handful of emails, answering a few calls, but that could put their entire exempt status at risk. Under the Fair Labor Standards Act, employers are not permitted to reduce a salaried exempt employee's wages in exchange for a reduction in hours. It has to be a permanent salary reduction. So normal FLSA regulations state, you can't just say, okay, it's summer pay, we're temporarily reducing pay for summer, and then go back. That's going to put the entire exempt status at risk. So other questions we're getting, if employers are having to pay non-exempt employees the same hourly rate or salary if they work at home. And, some things to think about here, if remote work is being provided as a reasonable accommodation, or to someone who's a qualified individual with a disability, or if there's something required by a union or employment contract, under those circumstances, then you're going to have to pay the same hourly rate or salary. But generally, under the FLSA, employers are just required to pay non-exempt employees only for the hours that they actually work. And again, salaried exempt employees are generally must receive their full salary in any week in which they perform work, subject to some very limited exceptions. Now I'm going to turn this back over to Meredith to talk some more about remote work policies with coronavirus.
Yeah, hi everyone. Remote work policies. I'm on day 3 of official remote work now. I think probably a lot of you out there are and your workforces are. If you did not already have a remote work policy in place, or even if you did, because this is such an unusual sort of emergency type situation, it's a very good idea to put a remote work policy in place. And I think also a very good idea to fashion it as a temporary remote work policy so that you can make sure that you tailor it exactly to these unique circumstances and don't have to worry about possible implications of your sort of normal day-to-day work life, assuming and hoping that we all go back to normal day-to-day work life sooner rather than later. So it's really important that your remote work policy conveys to employees that basically they're expected to help maintain normal business operations and do their job as normally as they can, with the only difference being that they're doing it at home instead of at work. Some considerations that you might have when you're talking about implementing remote policies is how strict is the policy going to be? And this is something that probably depends on what we're hearing from the government in terms of the level of severity of risk that everyone has with coronavirus right now. Based on, the current situation and risk levels, it's okay to have a policy that is, encouraging people to work from home. But if you don't want to require them to work from home for one reason or another, as of right now, that's probably okay. But that's something that might change as the situation in society progresses. And of course, you always need to consider who are your essential people, who do you absolutely have to have in the office, and handle the situation with those people differently, and explain to them in particular the importance of all the normal hygiene practices that we were all focused on, last week and the week before when we were also working together: hand washing, keeping stations extra clean, extra cleanings of offices, and all of those important precautions. You also want to clearly communicate with your remote workers your expectations for their availability. Best practice is to require people to generally be available at all times during regular working hours. But in these unique situations, especially if schools are closing and people are teleworking with kids in the house and trying to manage all that, it's a good idea to keep in mind that everyone's lives are very disrupted right now. And you, I think, want to come up with a manageable way so that people can get the work done that they need to do and also not have to take leave. If it's possible for them to do their job from home, I think that it's good for companies to try and be flexible and come up with arrangements that will allow them to get their work done and meet their other obligations with their family and not have to go into a leave scenario. Another thing to consider is how to handle meetings online, by phone, video. Will you prohibit employees from meeting together person to person during this time period? These are all, most of this is sort of business, HR, common sense consideration type stuff with fewer legal parameters. So it's good to just make these decisions using common sense, using good advice, and with the mindset of trying to to help your employees and also, you know, your customers and your patients and your partners, and balance everything with your policy. And of course, importantly, as with everything that we're talking about, it's important to not discriminate when you're using remote working policies. You want to make sure that your policies are applying across the board, and that, you know, you're not taking things like family type, or whether people have children, or whether they're a mother or whether they're a father, whether you're not making blanket differences in your policies based on those types of characteristics. You want your policy to be flexible and be able to adapt to different situations, but not to be drawing firm lines in the sand based on protected categories. And it's also, of course, important to do the best you can to ensure that your remote workers are actually doing their job, and that they're being productive, and that they can be productive. So you need to think about, will you provide employees with necessary resources if they don't have them, like computers, to work from home? It's good to agree on a single communications platform. How do you want your workers to communicate with each other? With the issue of whether you will provide employees with necessary resources like computers, the Department of Labor's guidelines don't mandate reimbursement for expenses incurred by employees as a result of remote work when it's implemented during a pandemic like this. But there are some states that might have individual requirements regarding reimbursement. So if you have employees that are incurring expenses in order to work from home under a mandatory work from home policy, it's good to consult state and local law about whether you might be on the hook for having to pay for anything that they're having to come out of pocket for. Also, productivity issues are important. Consider whether remote work could result in reduced productivity. But also, you want to sort of balance that with not babysitting your employees and not micromanaging them. You want to try to keep an eye on the big picture and try to figure out ways that you can track employee productivity and employee engagement without seeming like you're a big brother and you're, you know, requiring them to turn on their video camera and watch them while they work all day. It's just sort of a balancing act of, you know, when you're getting close to privacy considerations, you want to be very, very careful that what you're doing is something that's absolutely required by business necessity. And of course, I think those of us that have been working from home now for a while, employee burnout studies show that employees who work remotely have higher rates of burnout, especially at the beginning when this is a new thing and they maybe don't know how to make sure that they're balancing their workload and taking care of themselves the way that they need to when they're working from home. You know, if people are waking up, turning on their laptop, starting to work and not breaking for lunch and not taking a break and not eating, you know, all these sorts of things, that can cause burnout really quickly. And also, of course, as Abby discussed earlier, wage and hour concerns. So, you know, you want to find ways to engage with your employees even when they're working remotely. Schedule virtual team lunches, daily or weekly meetings or check-ins. I think probably most of us hate the video function on sort of video meetings, but the value of that is you get some face-to-face contact. You get to see your team members. So I think every once in a while a video conference where everybody sees each other and talks to each other is a good idea and can really help with employee morale. Remote work and data security. This is something that I addressed a little bit earlier when I was talking about not wanting to be big brother. This is an area where we have new intersections between employment and data security and privacy issues. So I think the first place to start with this is look at your current policies. Do your current policies address confidentiality considerations? And if they don't, now's the time to make sure that you have a good confidentiality policy in place so that everyone knows that all company information and documents, whether people are working remotely or in the office, everything needs to be maintained absolutely maximum confidentiality. It's also important to train employees on security measures related to remote work. Make sure that if there are any particular devices or documents that need to be secured in a secure location, that employees don't have them just loose around their desk. A side effect of course, people working remotely is that they can use their personal devices more than maybe they would at work. So it's important to think about, depending on what your company does and how much protected information that you have, that you're only using. Do you need to have them only use company issued equipment, or can you set your remote access controls so that you can still maintain the level of confidentiality that you normally would have? At the end of the day, if some of these things are technologically difficult, or you're working quickly and trying to implement this, just make sure employees are notified in writing that all expectations related to electronically stored information and hard copy documents are the same regardless of whether they're working at home or in the office. The next big concern with the issues that we're seeing with COVID-19 has to do with employee safety. And the place that we always start with employee safety, regardless of whether it's a pandemic or any other safety issue, is OSHA's general duty clause. Employers must provide a safe and healthy workplace free from recognized hazards that are causing or are likely to cause death or serious harm. And OSHA also publishes what they call risk zones that can be very helpful to determine, you know, how you meet this obligation with your particular workforce. And they set out different levels of how high the risk of exposure is in your particular workplace, ranging from very high exposure risk with healthcare employees performing certain procedures that are likely to put the virus out in the community, or at least out in the office, all the way down to low exposure, medium exposure, which is probably our normal office environment situation, where you have minimal contact with the general public, a moderate level of contact with coworkers. And so once you figure out kind of where your workplace is, that can guide you in terms of how you take protective measures that you need to make sure that you're not basically exposing your employees to a serious risk of contracting the virus. I think now most companies that I'm hearing about have gone remote, so some of these considerations are not quite as pertinent. But if you do have a workforce, if you're a healthcare employer, certainly if you have a workforce where you have a lot of people who need to still be in the office and need to still be having meetings, then it's still important to consider what you should be doing to make sure that you're reacting and dealing with, as we're starting to see more and more actual cases being diagnosed of the virus, making sure that you're responding and keeping your workplace safe. The practical considerations here: prohibit business travel to areas with significant outbreaks. Make sure that you're keeping track of the constantly changing travel alerts and what the government is telling people to do in terms of traveling and not traveling, and make sure that you're keeping your company policies in line with that. That's always the safe, conservative route. Just, you can certainly provide greater protections to your employees, but at a minimum, make sure that your policies about travel and required meetings are complying with what we're hearing from the government. The incubation period, as we all have heard, is 14 days. So employees who have traveled to affected areas or possibly been exposed should stay home for 14 days. At this point, I don't think anybody should having large-scale gatherings with employees other than absolutely essential things. And of course, all the normal cleaning, hand washing, all of those practices continue to be very important. And now I will turn it over to Abby to discuss some best practices and questions that we've been getting.
Thanks, everyone. And also, I know that we're at time, but we are going to try this to rapidly wrap this up in the next few minutes, and then we're going to take a little bit of time and hopefully answer some questions that I think you might have. So first question, what to do when an employee has tested positive for COVID-19? Send anyone home who works closely with the infected employee for a 14-day period of time, just to help try to make sure the infection does not spread. Again, possibly less of a concern now that we're all going into a remote workforce. Do not identify the name of the infected employee, or you're going to risk a violation of confidentiality laws. The CDC has a good part on their website. There's a part for employers, and that can be helpful to looking at how to conduct a risk assessment about who maybe was in touch with the infected employee. That's something you can also ask the infected employee to identify individuals that they've worked with in close proximity. That's about 3 to 6 feet within the last 14 days. Also consider to ask a cleaning company to come in and do a deep cleaning, and if you're in a shared office building, inform building management. So can you require an employee to notify the company if they've been exposed, have symptoms, and have tested positive for COVID-19? Yes, any employee who becomes ill at work with symptoms should immediately notify their supervisor. And employees who have symptoms should be directed to remain home until they at least are symptom-free for at least 24 hours. And again, that can, sore throat, cough, any symptoms, wait until those have been cleared for 24 hours before they come back. Can an employee refuse to come to work because they are fearful of infection? Employees are only entitled to refuse to come to work if they believe they are in imminent danger. And this threat must be immediate or imminent, meaning that an employee must believe that death or serious physical harm could occur within a short time. So maybe this could be an example, requiring travel to China or working with patients in certain medical settings without, personal protective equipment. Most work conditions in the United States are not going to meet these elements for an employee to refuse to come to work. However, do be mindful of the ADA. Someone with an underlying medical condition, that could change the situation. You may want to, take into ADA and reasonable accommodation concerns. Also, requiring a sick employee to be tested for COVID-19 before returning to work. Yes, you can seek to have an employee tested, subject to the availability of tests, if you have good cause to believe that the employee might pose a direct threat to the health and safety of others. This is something to be determined on a case-by-case basis and can be factors considered such as when the employee became sick, symptoms known to the employer, whether the employee had traveled recently to an area with a known outbreak, and if the risk can be eliminated or reduced by requiring the employee to work from home for a period of time. Now I'm going to turn it back over to Scott for just a little bit of wrap up on some benefits issues and further guidance on that.
Thanks, Abby. And I'll be brief here since we are running over. I wanted to just highlight a few things for you, even if you just hear the sound bites and then go look at it later. Just wanted you all to have this to think about going forward. So high deductible health plans, typically you can only cover preventative care expenses before someone satisfies their deductible. There was guidance last week that will allow you to use your HDHPs, high deductible health plans, to pay out COVID-19 related testing and treatment expenses as if it's preventative care, so people don't have to go out of pocket in their deductible before they can use their high deductible health plan. A lot of carriers on the fully insured side have said that they will be waiving copays for testing. Remains to be seen about treatment. Right now, we're hearing most of the major carriers have waived copays and out-of-pocket expenses for testing. That's not the same for a self-insured plan. So if you're a self-insured employer, it's a case-by-case basis. You'll have to talk to your third-party administrator and your stop-loss carrier to determine whether you will be waiving the copays and the cost sharing for out-of-pocket expenses related to testing. And it's going to be on a case-by-case basis based on business reasons. Telemedicine, carriers love to push out their telemedicine options. A lot of folks ignore those. Now's a great time to dust off your brochures about telemedicine. Your carriers or your brokers, your service providers can resend those to you, and you can send those to employees. But we're seeing a big uptick in telemedicine visits, especially for non-essential things or diagnoses. HIPAA reminders. If you have a health plan that receives PHI, just remind your employees to keep PHI confidential. We're seeing more and more questions and risk around employees wanting to determine whether someone went and got a COVID-19 test and what the result was. There's an employment records exception, which could be the basis of an entirely different webinar. But for this purpose, just know that if somebody comes in through an employment-related reason and tells you that they've tested positive for COVID-19, generally that's not going to be PHI. But if you go to your health plan administrator and ask them for the result, that will be PHI. And we see a big risk here of employees going to check those records on their own to determine whether there's been anyone in their area or at their company who's had a positive diagnosis of COVID-19. So just send out a reminder to all of your health plan administrators, of their HIPAA obligations. Section 139 plans, these seem to have been popping up more and more. You can use a 139 plan to pay reasonable and necessary expense reimbursement to employees related to COVID-19 and other natural disasters. I'm not going to go through all the tax extensions. There were several tax extensions that were passed this week and last that relate to the payment timing of income taxes related to 2019 and also for estimated taxes for the first part of 2020. We have a legal alert out on this, and this slide summarizes that. You all will get copies of the slides if you do not have them already, and that will allow you to kind of go through that and parse those rules. There is a follow-up tax extension bill that's passing right now. It's going through Congress right now. Senate passed legislation last night, not just extending the payment deadlines, but also the filing deadlines. So kind of just stay tuned with taxes, but it's looking like people are not even going to have to file their taxes in April, much less make payments. So a couple of housekeeping items here. There are a significant amount of questions. We will stay on the line and answer several of the questions. If you guys need to drop, feel free to drop. If you've asked a question and we don't get to it, we will respond to you after the webinar, and we will either set up a call to talk to you about it if we need more information, or we'll try to answer it the best that we can. Real quick, before we dive into a couple of questions, I do want to let everyone know that we have a significant amount of resources for COVID-19. You can visit our COVID-19 Task Force website, which is the link there on the last slide of the deck. And we have planned upcoming webinars related to this topic that will be of interest. We're doing a cybersecurity and privacy webinar related to working from home and some of the remote connectivity issues that come with that, as well as a force majeure insurance and contract clause webinar. More information about those will be out next week. Okay, so housekeeping items out of the way. One last thing to mention, Amelia will be sending out an email with information about how to apply for credit for CLE or HR credit that we'll be applying for, and we'll have all the information of what was approved after the webinar. So with that, I'm going to actually turn it back over to Meredith and Abby to talk about some of these questions. A lot of these are employment-based. So if Abby and Meredith, you guys see a few that you want to address here, take it away.
Okay, hi everyone, it's Meredith. The first question that we got relates to the federal legislation regarding paid sick leave and expanded FMLA. And the question is, does this only apply in the situation when somebody cannot telework at all because a child is at home? And the questioner points out that obviously this is going to be difficult to manage if it applies whenever school is closed, because obviously schools are all closing. And I believe, yes, it's correct. The way that the statute is written is that the FMLA benefits and the paid sick leave apply if the employee is unable to work or telework. So that means that if the employee can still work from home, then they shouldn't be entitled to get the benefits. And that's actually something that changed as the bill was passed back and forth between the House and the Senate. That language, or telework, was specifically added by the Senate before the bill was passed. So the intention here is that this should only apply if one of your employees is completely unable to work from home, telework, as a result of, for purposes of FMLA, having to care for a child whose school or place of care has closed. And under, paid sick leave, it applies for multiple different reasons, including the employee's own health or having to care for someone else. And also the paid sick leave applies if the child's school or place of care has been closed. So, I think obviously the question with that is probably going to be, well, if they can still substantially perform their job, what level of work do they need to be able to perform? And those are all questions that we don't really have an answer to in the law, but will surely be hammered out in the coming weeks as you have specific issues arise with your employees. But I think the general guiding principle is the employee, in order to take these benefits, has to be unable to work either in the office or from home.
This is Abby. I'm looking at something about benefits being in addition to existing benefits. And yeah, one thing I did want to note is that the provisions in the paid sick leave provision actually specifically prevent an employer from being able to go and change their sick leave policies or vacation policies in light of this new legislation. So yes, this is going to be in addition to existing leave that's provided to employees.
And the next question, sort of a similar issue, where you have an employee who is getting 2/3 of their pay under the new federal legislation. So they're getting 2/3, they're not getting their whole pay. The question is, what if the employer wants to supplement that with PTO to make the employee whole? And, you know, generally with these employment laws, there's no issue with an employer wanting to provide greater benefits to their employees than what's required. So from an employment law perspective, no issue. If you want to, you know, make your employees whole and pay them their full salary instead of just the 2/3, shouldn't be a problem. Scott, I'm not sure if there are any potential benefits or tax issues related to an employer doing something like that, but from an employment perspective, shouldn't be a problem.
And I think you would just want to make sure that you're, you know, doing it consistent, not being discriminatory towards any employees. You know, you're not pick and choosing and doing that for some employees and not others.
Right, and it would depend a little bit on the facts and circumstances a little more. I have a couple of follow-up questions for that for the benefit side, but we could talk offline if there's a question that was.
Yeah, I think that the interaction of how your existing leave policies are going to work with the new expanded FMLA and paid sick leave benefits is going to be something very fact specific depending on how you currently implement your policies and what type of policy you have. We've been seeing people wanting, prior to coronavirus, people moving towards unlimited PTO plans. If any of you have spoken to me about it, I probably highly discourage you from doing it because from an employment law perspective, it can be extremely difficult if certain situations arise. And here we are in one of those certain situations where if you have an unlimited PTO plan and now you've got this going on, it's going to be just require a little bit more, you know, revising and issuing new policies and figuring out the mechanics of how you'll manage an unlimited PTO policy with all this. So, you know, what we know right now is that employees are allowed to elect to use their existing PTO and vacation time to get, you know, paid fully during the required leave periods. The question of can you make them do that, you know, is up in the air. I think there's you can make a good argument that the statute doesn't prohibit it, but we know that there are some people in Congress who don't think that because they pushed really hard to get an express prohibition in the law. So that if you're interested in doing something like that, it's worth, I think, looking closely at your policies and how you want to administer it and doing the research, as much research as we can to give you guidance about how that might be viewed.
Yeah.
So I see a question here related to benefits that I can tackle here. Can an employer opt to extend COBRA, and how much flexibility does the employer have in terms of the length of COBRA coverage and who pays for it? All right, so yes, an employer could extend COBRA or provide COBRA where COBRA does not otherwise apply. Doing so, though, could put you at odds with your insurance carrier or your stop-loss carrier. So if you are going to provide an exception to what's minimally required under COBRA that's not in your plan document now, then you would need to get separate approval from your stop-loss carrier if you're a self-insured plan or your insurance carrier if you're a fully insured plan. If you make an exception like that without getting the prior approvals first, those carriers will a lot of times deny those claims because they're not covered under the terms of the plan. In terms of who pays for it, there's some flexibility here. It's going to be facts and circumstances depending on whether you have a fully insured plan or a self-insured plan and who the employee is, whether they're a highly compensated employee or not. But generally, yes, employers can and do contribute toward the cost of COBRA for employees, either full pay or they'll continue to allow the employee to pay the active employee rate in effect at the time. COBRA can be pretty expensive, and COBRA is a 100% of the cost of coverage. So that's the employer and the employee side plus a 2% administrative fee. So up to 102% for the employee to pay it. A lot of times that can well approach $1,000 a month. And so sometimes employers will allow employees to continue to pay the active employee rate, whatever they were paying before, and the employer will pay the difference. That doesn't require approval, but if you're going to extend COBRA or provide COBRA where COBRA might not otherwise exist, that does need pre-approval.
Okay.
Another question here, I'll take another one here. On furloughs and benefits, if employees continue to get benefits, how are they going to pay for it? We addressed this a little bit in the presentation, but happy to kind of go through that real quick again. Two main ways. You can have the employee continue to pay in. So if in this example, looks like they're paying $100 a month for benefits, they can continue to write a check to the employer for those benefits. If they don't write a check for those benefits will, under the terms of the plan, terminate unless the employer is going to step in and pay it for them. That's risky to employees because if somebody doesn't pay it and their health insurance is canceled, a lot of times it doesn't result in COBRA coverage because the reason that you lost coverage was because you didn't pay it. A lot of companies, to avoid that administrative hassle, especially if there's a lot of employees, will just pay it for the employees. So if the cost of coverage is $100 a month, the employer pays that for the employee and then we'll recoup that when the employee returns. If they do that, it needs to be documented so that you can do the double deductions for the employee to help recoup that when they come back. And so there's no issue or concern about doing double deductions. Meredith or Abby, do you all have any other questions you want to address now, or you all want to wrap and then we can tackle some of these offline?
Sure. Yeah, I think we've tried to hit on the major points and the questions that we're seeing. Anyone who has further specific questions, any that come in, I'm seeing some I think that I didn't see earlier. So any that we missed or that come in later, we'll reach out to you individually and answer your question. And of course, we're always here and available to help you get through these very challenging times and address all the gray areas and the vague situations that we're going to be encountering in the future. And like Scott said earlier, please visit our task force resources and stay tuned for further webinars in the series. We're still finalizing the schedule, but the topics that we do want to handle through webinars in the future include force majeure, contract, and other corporate business issues related to coronavirus, and also privacy and cybersecurity for the remote workforce, which we touched on a little bit today, but there's really enough there for a much more in-depth webinar. So we hope that you can all join us next time.